Thank you very much for joining us today. We realized that we had our lectures last week on international organizations and regional global governance. And today we have our special guest speaker for the week, Dr. Penelope Ridings. A warm welcome, Penelope, from Nilofer, myself, and on behalf of the CIL eAcademy. We're so happy to have you with us today to speak about the role of decision-making mechanisms in the context of international organizations and global regional governance. We are, as I said, so happy to see you, and of course I wanted to introduce you to our participants. We are very honored to have Dr. Penelope Ridings as our colleague in the International Law Commission since this year, and Penelope has been an extremely active new member in the Commission, and it's been a pleasure working with you this past year. And of course, I have to highlight that one of the few women in the Commission, because I think our participants by now know that we're only 5. And so besides Nilofer and myself, Benny is one of the 5 women members of the International Law Commission. And it's been a delight having you as colleague. But of course, that's only one very small highlight of Dr. Penelope Ridings' career, which has been extremely active and dedicated as part of the New Zealand diplomatic service, and in particular in the legal area, since Dr. Penelope Ridings has been acting as a legal advisor for a number of years in the New Zealand Ministry of Foreign Affairs. And in that position, she, of course, participated in many international negotiations. She was also agent before the International Court of Justice in the whaling case, which is actually when we first met in the corridors in the Hague, and of course a negotiator for New Zealand in a number of international treaties and agreements. With a lot of work in the area of the environment and trade, and I'm sure that you will give some examples of your own experience to the participants. Recently, I think you still have the functions of being the legal advisor in the, let me get the name right, because it's a technical body. I'm just getting the name right. Is it the Tuna Commission? I'm getting my names wrong. Is it the Pacific Tuna Commission?
That's the easiest way to refer to it.
Yes. Okay. So I was trying for the short name. So you see a great and varied experience as a diplomat who's been posted to several countries, legal advisor of New Zealand, experienced negotiator, agent before the ICJ. So we could not be happier to have Penny with us to speak to you, also based on her experience about decision-making in international organizations. And so the floor is all yours. Thank you very much.
Well, thank you very much, Patricia. And I'd like to also first thank the National University of Singapore and the Centre for International Law and the eAcademy. And it's a real pleasure to be invited. And it's a real pleasure to see my dear colleague, Patricia, again. I have to initially indicate the perspective that I bring to this topic. First, as Patricia has indicated, I bring the perspective of someone who works for a regional fisheries organization as its legal advisor. So I bring experience as effectively a member of the secretariat of an organization, so a perspective from the inside of an organization. And so, therefore, some of my examples, not all, are from fisheries organizations. But second, as Patricia has indicated, I bring the perspective of someone who's been involved in negotiating treaties, including those establishing international organizations. And I've also participated as a delegate to international organizations. So in summary, my perspective is very much at the practical end of the spectrum. So my topic is on the role of decision-making mechanisms in international organizations and regional global governments. So I'm sure you will have heard last week, and it goes without saying, that there's been a proliferation of international organizations in the last half of the 20th century. And today, almost every aspect of today's life is impacted in some way by international organizations, whether it's sending mail, traveling by ship or air, or sending goods overseas. And some organizations have an even greater role in international governance, particularly the United Nations and the European Union. So international organizations as global political actors play a role in global and regional governments. And you'll know, I'm sure from last week, of the classical theory of international organizations law, the functionalist perspective, that states come together to give a mandate to an organization. And the traditional view is that states delegate functions and retain sovereign control over the organization. Although, as will become apparent, and as argued by Joachim von Bernstorff, there may be some question over the extent of the retention of state control in certain circumstances. So states see themselves as exercising control over the organization through decision-making mechanisms, which is set out in the constitution of the organization. And the plenary organ of the organization may delegate tasks to subsidiary bodies, such as technical bodies, or to a secretariat to undertake much of the day-to-day work of the international organization. So in looking at decision-making mechanisms, I want to first cover the various types of decision-making mechanisms and how they often operate in practice. Then I want to draw a distinction between the lawmaking of international organizations and other decision-making. It's in this area that decision-making mechanisms influence the role that organizations play in international and regional governments. And I will highlight, the role of soft law becomes particularly important. And I'll also look at the various ways in which decisions on soft law are developed. And then I want to cover some of the critiques of the decision-making process of international organizations, particularly as relates to effectiveness and legitimacy. So first, turning to the different types of decision-making mechanisms. So it is through the decision-making processes that international organizations play a role in global governance. The constituent instruments usually provide which legal acts may be taken by which plenary or subsidiary organ, and according to which decision-making procedures. But formal decision-making processes differ considerably from organization to organization. But in the main, decision-making is based on the principle of sovereign equality, and usually one state, one vote. There are some exceptions. For example, the World Bank and the International Monetary Fund are based on the financial contributions of member states, but that is a hark back to the time at which they were created. So looking at the methods of decision-making, the classic method is unanimity, at least when adopting binding acts. And this is based on the idea not only of sovereign equality, but also on the idea that states cannot be bound by international legal obligations without their consent. So an example from the past is the League of Nations, which required unanimity for all decisions of the Council and the Assembly, except for procedural matters. But also it applies still in some other organizations, such as the OECD, OPEC, and CARICOM, where in case of CARICOM, an affirmative vote of all its members is required. But there was a move in the latter part of the 20th century towards decision-making by consensus and away from unanimity. And this was driven in part by the increasing number of states and international organizations, which was a consequence of the decolonization process. So to be quite clear about what consensus means, it's the absence of formal objection. So this is where no delegation formally objects to a consensus being recorded. This doesn't mean that delegations may not have reservations on the substantive matters at issue, but if they do not formally object or do not request a vote, then consensus can be found. So a couple of recent examples of consensus decision-making are the decision in the General Assembly to refer a request for an advisory opinion to the International Court of Justice regarding climate change. And while not all countries may have agreed to this, there was no request for a vote. So therefore, for the first time since, I think, 1955, the decision of the General Assembly to refer a request for an advisory opinion was adopted by consensus. Another example is the adoption of the BBNJ Treaty, which concerns biodiversity beyond national jurisdiction. Again, that was adopted by consensus. Not all states necessarily agreed with the final text, and a few have indicated they will not sign, but no state formally objected. There was a variant on the consensus method, which is consensus with the possibility of vote if consensus is not obtained. Both the ICJ advisory opinion and the BBNJ treaty were examples of this, because both did provide for the possibility of a qualified majority vote if consensus was not reached. So there is a question of whether in practice there's a difference between unanimity and consensus. But I think in practice there is a difference where consensus decision-making is made and under the shadow of a vote. And so there's various reasons for states not wishing to formally object to a decision. So especially if, for example, they can signify their views through not adopting or signing a convention or not participating. And it seems to me that peer pressure is often very influential in these instances. So turning to the qualified majority vote, which is often the alternative where consensus cannot be reached. In the UN Security Council is the classic example where 9 out of the 15 members of the UN Security Council is required, and there must be no veto by one of the permanent 5. But there are other cases, for example, in the case of decisions of the Council of the International Seabed Authority, voting is divided into chambers for the qualified majority required in each chamber. And the same approach is adopted in the Pacific Tuna Commission, which its full name is the Western and Central Pacific Fisheries Commission. That's for that reason I refer to it as the Pacific Tuna Commission. And their voting is in 2 chambers, the 16 members of the Foreign Fisheries Agency, in essence, the coastal states of the Pacific region, and others, mostly distant water fishing nations. But it's notable that while there is a possibility of voting has never been used in practice in the organization. All decisions to date since entry into force in 2002 have been undertaken through consensus. There's another variant of decision-making where a decision may be taken, for example, on a fisheries conservation and management measure, and states are given the right to object or to opt out of the decision. So some specifically provide for this. So, for example, the Indian Ocean Tuna Commission provides for the ability to opt out of decisions, but this can adversely impact on effective measures by the organization if measures can be opted out of after they have been adopted. So looking at how decision-making mechanisms operate in practice, there's a lot of theoretical studies of decision-making, but they hide many of the real issues in decision-making, which in essence is how consensus can be reached. And there's various mechanisms and ways in which consensus can be reached. Some of these involve the role of small groups in trying to hammer out a consensus among a smaller group of countries. But that raises issues of transparency, because if those countries are not in the room when the final deal is hammered out, there's a real concern over whether they should be agreeing to it. But I also find the role of personalities in decision-making is really quite remarkable, and much will depend upon the individual strategies as well as the government positions of the various members of the organizations. With unanimity, there's sometimes a view that the most obdurate gets what they want, and sometimes this is due to the personalities of the delegates. But I think this is a bit simplistic. In practice, unanimity is pretty close to consensus decision-making. And often consensus is formed through package deals where nothing is agreed until everything is agreed. And so there's a process whereby members will consider each issue, but park it and then come back to it, depending upon the response to other issues. There's also a potential in consensus decision-making for horse trading to take place on difficult issues. And often this horse trading is behind closed doors. And there's also various techniques used to try to reach consensus, and one of which is the drafting technique of using constructive ambiguity, where it's not quite clear from the drafting of the text what is the actual legal binding obligation. And so different states can interpret that in the way that they like. And this is not something which is good practice, can I say. There's also a role for what's been termed the conference method of diplomacy, where regular conferences have a defined time limit. And with a defined time limit, if you have a certain number of days that you have to meet and come out with a conclusion, there's a huge impetus on the conference to reach a decision before the expiry of the time limit. And there's various mechanisms which I've seen operate in practice. One is to what's called stop the clock. So if the meeting is supposed to finish at say, 7 o'clock or 6 o'clock when the translators go home, the clock has stopped and they continue the negotiation until the negotiation is finalized. So in one case I was participating in it, it concluded at 1 a.m. and another one at 3 a.m. So the BB&J conference was an example where they just kept negotiating and just until the final result was reached. But I would also note that decision-making in international organizations doesn't take place in a vacuum, and there's various influences on decision-making. And this ranges from NGOs, civil society, participating in the negotiations, and also representatives on delegations. So in the fisheries context, members of the fishing industry and members of the environmental organizations can participate in delegations. And so often getting a united delegation position can often be quite difficult. And it's those additional delegates which can influence decision-making. But still, I would say that the number of organizations that can take binding decisions by some form of majority and thus outvoting some member states is very low. But there may be different decision-making procedures with respect to extent to which they bind their members. So it seems to me there's two basic types of decisions. Lawmaking, where the states are under a legal obligation to comply, and recommendations or guidelines, which are non-binding and where implementation is left to the members of the international organization. And I think scholars also add to these internal rules, which I don't intend to address. So when addressing lawmaking or standard setting, decision-making mechanisms are really important. And usually in international organizations, binding lawmaking decisions on substantive policy are usually only taken by consensus or unanimity. And usually such rules have to be incorporated into domestic law by the member states. So the EU is an unusual example whereby its treaty on the functioning of the EU clearly indicates that regulations, directives, and decisions are binding. But even there's a distinction. Regulations are binding and directly applicable. Directives are only binding as far as their result is concerned. And member states are left to choose how to achieve that result. And in contrast, recommendations and opinions have no binding legal force. So in the EU, there is therefore majority voting with the effect of binding members, even if they disagree. And EU law takes precedence over domestic law. And this is what has led scholars such as Jan Klubbers to refer to the EU as supranational, in that it stands above its member states, but it is an exception. So the mechanisms of qualified majority voting in an international organization, with a consequence that it binds a state that didn't vote in favor of it, is very rare. There are some examples in addition to the EU. For example, the UN Security Council resolutions on terrorism. So Article 25 of the UN Charter provides that the members of the UN agree to accept and carry out the decisions of the Security Council in accordance with the Charter. And there's a number of quasi-lawmaking UN Security Council resolutions on terrorism, which are effectively binding on all members of the UN, including the resolution on financing of terrorism and the resolution on foreign terrorist fighters. There is quite an unusual example, and again, it comes in the fisheries context. And it's in the case of the South Pacific Regional Fisheries Management Organization, which again is a very long name for an organization, but we shorten it to SPRIFMO. So in SPRIFMO, the decision-making process is consensus, but if consensus can't be reached, recourse can be made to a qualified, a 3/4 majority. And there's 12 members. But there's a fallback in that if a member objects to a decision and it is outvoted, it may seek a review of the decision by a panel of 3 arbitrators. So the grounds of review are very limited. They are that the decision is inconsistent with the provisions of the SPRIFMO Convention or with other relevant international laws, such as the UN Convention on Law of the Sea or the 1995 Fish Stocks Agreement, or that the decision unjustifiably discriminates in form or in fact against the applicant. So this process is very expeditious. And since 2012, when the SPRIFMO Convention came into effect, it's been used 3 times. So in the most recent case, in 2023, so this year, the review panel found that a decision by the SPRIFMO Commission concerning the allocation of jack mackerel unjustifiably discriminated in form or in fact against Russia. And it also recommended a specific modification which effectively set the catch allocation for Russia. So this is the first time that the review panel had found clearly in favor of the applicant. And one of its justifications was the fact that the allocation mechanism, which had been agreed in a small group process and then taken to the commission, was for a 10-year allocation. And so it was felt that this, if it had been, the previous ones had only been a 1-year allocation, it was felt that a 10-year allocation discriminated against Russia, which was not able to adequately sort of represent its views, to have the commission take into account its own concerns over its allocation for jack mackerel. Well, it's interesting too that the Pacific Tuna Commission has a very similar provision in its convention, but unlike SPRIFMO, the Tuna Commission Convention requires consensus for core decisions affecting the central core interests of its members, including budget, the admission of new members, and the allocation of fishing opportunities, all of which have to be by consensus. So SPRIFMO did not include that in its convention. So if international organizations find it difficult to take binding decisions because of the unanimity or consensus rule, they may seek to resort to non-binding resolutions. So non-binding resolutions can be a useful way in which to take action where states would not or could not agree to a binding decision. And of course, any such action is not binding. So there's a large category of actions taken by international organizations which aim to influence behavior, but which are not binding. And they come under various disguises, such as recommendations, declarations, guidelines, or codes of conduct. So in the Pacific Tuna Commission, we had calls a few years ago to address and improve labor standards on fishing vessels, particularly those distant water fishing vessels fishing on the high seas. Initially, agreement was reached on a non-binding resolution, and it was quite clear at the time that agreement was reached on the basis that it was non-binding. And now work is now underway on a binding conservation measure to place obligations on members with respect to labor conditions on their flag vessels. But this is not an easy issue at all. So turning to another way in which soft law can be introduced by international organizations, in some cases, even though the instruments such as the standards are not binding, they may become binding through their incorporation as a rule of reference. So, for example, the Codex Alimentarius, which is a joint venture of the Food and Agriculture Organization and the World Health Organization, initially set non-binding guidelines on food safety. However, this Codex Alimentarius can be relied upon by the World Trade Organization member states to justify food standards, their domestic food standards under the WTO's agreement on sanitary and phytosanitary measures. And under the UN Convention on Law of the Sea, regulations of the International Maritime Organization, for example, can become binding on UNCLOS parties through their incorporation as rules of reference relating to shipping and navigation. And this rules of reference approach was also cited frequently in submissions to the International Tribunal on the Law of the Sea in relation to the advisory opinion on climate change in relation to protection of the environment. So there's other examples where standards effectively become binding. So an example is the International Civil Aviation Organization, which adopts international standards and recommended practices. So states are expected to implement the standards and recommended practices to the extent practicable. But for a number of reasons, including the fact that they've often been incorporated into national law, and because of the commercial aviation industry demands compliance with them, these standards and recommended practices are effectively binding. So in some other cases, delegated power is given to the subsidiary organ of an international organization. And the classic example here is the delegation of power to the UN Security Council in respect of international peace and security under Chapter 7 of the UN Charter. But another example is the World Health Organization, which can enact regulations on issues such as the names to be used to describe diseases, or more importantly, declaring a public health emergency of international concern. And these become binding on member states unless the states opts out within a fixed period of time, and none has done so. So as the COVID-19 crisis illustrates, a decision by the World Health Organization to declare a public health emergency of international concern had very wide-ranging economic and political and social effects. So this is effectively an example of opting in or opting out of decisions. And some international organizations can develop treaties which only become binding following ratification. So this is the opt-in approach. And the International Labour Organization is a good example. But others may adopt an opt-out approach. So, for example, the 1985 Vienna Convention for the Protection of the Ozone Layer and its subsequent Montreal Protocol provide a framework for members to take action in respect of ozone-depleting substances. The conferences of the parties establish technical annexes, which can be amended by a qualified majority, which could be opted out of, otherwise they're binding on all parties. So if you don't opt out of it, it's binding. And I would note that in terms of the ozone layer, this set of conventions have been one of the most successful use of international governance by an international organization. And the final example of sort of soft law mechanisms, which are not binding, but which rest on moral persuasion and peer pressure on governments, are the multilateral surveillance mechanisms. And the most cited example of this is the International Monetary Fund's multilateral surveillance through its annual consultations with individual members to give, and I quote, advice on financial and monetary policies. But another also is the Financial Action Task Force. So this task force was founded in 1989 by the G7 to combat money laundering by drug trafficking and organized crime networks. And it's since expanded its role to counter terrorism financing and weapons of mass destruction proliferation financing. And more than 190 member jurisdictions are sort of involved in FATF, which is the Financial Action Task Force. And it has a global network which is committed to implementing, being evaluated for compliance with FATF standards. And while non-binding, the peer pressure to comply is great. And so if you have a FATF team coming in investigating, you want to make absolutely certain that your domestic legislation and your implementation of it is completely compliant with FATF standards. Otherwise, FATF will hold you to account in the court of public opinion. So these are some examples of soft law, and some soft law are harder law than others. But what is clear is that soft law often emerges as a way to overcome the conflicting views in substance which take place in international organizations. But turning, there's a critique of decision-making. First is the effectiveness. This is of significant concern in a number of organizations, and we all know well what's happening in the UN Security Council with the situation in Gaza, and what happened with respect to the Russian invasion of Ukraine and the veto power of the P5. But the World Trade Organization has not been able to pursue its multilateral negotiation agenda following the abandonment of the Doha development round. And I've already mentioned the Indian Ocean Tuna Commission, which is not being able to effectively concern yellowfin tuna because of its opt-out procedure in particular. And so there's concerns over effectiveness. Is there a way to fix this? It's very difficult to amend the constituent instruments of international organization because it requires agreement of states parties. And there's been attempts in some cases to adopt procedures to facilitate decision-making. And for example, the UN Charter Committee has been operating since 1974, but there's not been a lot of success. So the inability to bring about change in decision-making processes has led to calls for a different approach to increase the legitimacy of international organizations. So the functional theory of international institutions law deals with the relationship between members of the organization and the organization. Legitimacy affects the relationship between the organization and other stakeholders, which are non-states, and this can be range from international non-governmental organizations to individuals. And the concern is that the checks and balances between different organs of the international organization can be lacking. And so there's a number of criticisms. One is that there is no legitimating connection between the lawmaking at the international level and the lawmaking at the domestic level. So this has been referred to as a democratic deficit by Jose Alvarez in particular. And second, international organizations are perceived to lack transparency and involvement by civil society. And so Anne Peters, for example, considers that those assessing an organization can only do so if there's sufficient information about the organization and its activities, and that transparency safeguards state sovereignty. I would also add that international organizations are very patchy on the participation and involvement of civil society in their organizations. Some grant accreditation to NGOs, but for example, the WTO has no provision for civil society to attend WTO meetings. By participating in an international organization, NGOs representing civil society can contribute to holding those organizations to account and can assist with the legitimacy of those organizations. So I don't want to diminish the role of international organizations in global and regional governments. Decision-making procedures serve to act as a balance between the members of the organization, but the organization and their decision-making processes operate best when the interests of all the members are in alignment. So thus in the Pacific Islands Forum, which is currently meeting in Rarotonga, it can take substantive decisions on matters of interest by consensus. That doesn't mean to say that it's always easy to reach agreement, but being aligned in views is an advantage in an organization. So my conclusion, decision-making mechanisms play a role in regional and global governance, but they're not the solution in and of themselves. efforts to increase legitimacy of the organizations can help to enhance improved governance by those organizations. So I'm very happy to answer any questions that you may have on these issues. And thank you for listening so intently.
Thank you so much, Penny. I think as you said, you came to this issue with the perspective of a practitioner, and I think only a practitioner could have given us in about half an hour or 40 minutes, I mean, the in-depth analysis of the different ways of working of international organizations that you can really only know and explain when you know organizations from the inside. I think a lot of these aspects that you mentioned, unless you've you've been involved in the work of the organization, are not so visible in terms also of their importance. From when you just read the founding treaties of such an organization. And so the differences between how the UN works, the EU or the Pacific Tuna Commission, and why things are the way they are, it's extremely important. And I would have a question that I wanted to ask immediately, but I'm going to see if our participants want to see if there's something in the Q&A or the chat, because sometimes they use both. I don't see anything now, so I'm waiting for maybe participants. Please feel free to raise your hands if you want to ask a question. So maybe I'll take the opportunity and ask. But before doing that, I recognize that Niloufer's joined us, and so I wanted to also welcome her. I'm sure, as I said before, she's also thrilled to have you. Niloufer.
Yes, just a quick hello. Apologies for being late, but it's wonderful to have you, Penny, joining us today as our distinguished lecturer. And I'm sure that the participants have learned a great deal from you. So I'll let them ask some questions, or Patricia, go ahead with your question.
I'm still monitoring. Okay, so we do have a question in the Q&A about the ASEAN-X principle, which I confess I'm not familiar with. This is, I can see the full name for some reason. It's one of the participants from Singapore. I cannot read the full name in my screen. Do you think that the ASEAN-X principle is another recourse to adopt special economic agreements if it fails to achieve its principle of consensus? So that would be one question, and then I see there's another one in the Q&A. So maybe I'll leave you with that first question. Please,
yes,
Penny.
Well, thank you very much for that question, Mr. Lee. So I think you're right. This is the trouble with giving a presentation like this, is that there's so many different variations of the types of decision-making mechanisms in international organizations that's not possible to cover them all, but certainly the approach of having, sort of the ASEAN minus X principle is especially useful. The issue with economic agreements is that ASEAN has entered into economic agreements, regional free trade agreements with both New Zealand and Australia, called ANZFTA. And but that included everyone. The point about economic agreements is that, in essence, they should only bind those which have agreed to participate in the particular economic agreement. So if you have a ASEAN minus X, it means that, in essence, a country which does not wish to enter into that agreement does not hold up the rest of the ASEAN members from entering into an agreement. And so in that regard, it's in essence the binding nature of the agreement is only binding on those who are party to it. And so it's a good mechanism in order to reach agreement on an economic agreement. which so it's a useful mechanism. And I see there's another question there as well on the Basel
Yes,
Committee
and
on
there's
banking.
yes, one on the Basel Committee in the Q&A, but I'll just also read. I'll alternate with the chat. And again, the participants, feel free to raise your hand and ask a live question. But we have one from Mr. Ajema from Ethiopia about the Security Council, which is of course an unavoidable topic on how is it how can we expect the Security Council decision to be free from bias in case of one of the members has a conflict of interest, like in the case Russia-Ukraine. So the classical question about the decision making in the Security Council and the veto power and being an interested party. And then there's the question about the Basel Committee. So I'll leave you with both.
Okay, so first on the UN Security Council, there isn't any mechanism for a member to be, to not be able to vote because they have a conflict of interest. In essence, this is a bit of a problem. And I would say that New Zealand opposed the veto to the P5 at the time of the San Francisco Convention, and we still oppose the veto. But it exists. The UN Charter Committee is trying to explore these sorts of mechanisms, but the fundamental problem is that any result of the Charter Committee, even if it's just from a procedural perspective, would need to have the agreement of the P5, and so it's unlikely to occur in practice, particularly at the moment. So I mean, I agree with your fundamental premise that how can we expect the UN Security Council decision to be free from bias when one member says a conflict of interest? Yes, but that is why we have the Uniting for Peace resolution from the General Assembly, which of course just met in respect of the Gaza Strip, and previously has met in the case of the Russian invasion of Ukraine. So the Uniting for Peace resolution does give the ability for the General Assembly to issue a resolution, and the strength of the number of countries voting in favor of that resolution is often an indication of international peer pressure. And an indication of the international community's views on a particular issue. On the question about the Basel Committee on Banking Supervision, yes, it's not an international organization, as you point out, but there are standards of regulation, and it's up to individual states as to how they implement those standards. There are other similar ones, which is not sort of international organizations per se, but are standard setting bodies. So the FATF, the Financial Action Task Force, is not actually an international organization. I don't think it falls within the definition of international organization. But another one is the International Standards Organization, which also sets standards. And often it's referred to by other standard setting domestically, standard setting bodies. And they, similarly, there are other standard setting bodies, which may not be technically international organizations because they're not composed of, member states with a constituent established by treaty, and expressing well, you probably heard from last week, having an organ that expresses its distinct will. So yes, there are some other ones as well. So I hope I've answered your question, Mr. Lowe, sufficiently.
Thank you, Penny. So let me see. Okay, we have one more question in the chat. if it is possible to adopt consensus procedure of decision making as an alternative to unanimity or qualified majority, despite the absence of stipulation in the constitution of IOs. And I think that's what happens in the UN. and my question was related to that, but I'll let you answer this first, and then if there's time, I'll ask my question. Please,
yes,
Penny.
if the constitution of the international organization refers to unanimity, in practice, that turns out to be consensus. So in practice today and nowadays, unanimity, for example, in CARICOM or in the OECD, even though it's stipulated in the constitution that it's in essence unanimity, in practice it's consensus. The issue of the qualified majority is that you can always agree to something by consensus, even if the constitution of the international organization provides for a qualified majority. And in fact, it's always better to not go to a vote. So, for example, my understanding, I'm not an EU expert at all, but my understanding in the EU is that even though it provides for qualified majority voting in the council will make all efforts, and so the various subsidiary bodies which lead up to the council, of which is many, in essence, the council endeavors to reach its decisions by consensus, even though the treaty does provide for qualified majority.
Yes, and indeed, we often have that discussion with regard to the UN, where rules of procedure don't speak specifically about consensus, and so that's an interpretation from the practice of the organization. So there's one more question in the Q&A, and again, I apologize because I don't see the full name, but it's our participant from Botswana about the inclusion of civil society in international organizations. It's not so much about the decision-making system, but it's about the access of civil society organizations in the activities of IOs, and how would that access, what kind of access would that grant, and if there are any good models. So it's a little bit not totally related to the question of the decision making, but maybe you would still care to comment if you can.
Yes, I think that there are various models for allowing civil society organizations to participate in the activities of the international organization. So the most frequent way is where they seek accreditation to participate in the meetings of the international organization. So again, using my fisheries background, and for example, in the Pacific Tuna Commission, there are rules of procedure which provide for the participation of NGOs, and so on an application, and they are permitted to speak, at the invitation of the chair. They make statements. They can deliver papers, and in this way, they also quite. Can I say they use the media very well as well? So they're often in the media, and they help to encourage the international organization to move in a particular direction. So there are a lot of sort of good examples of how this can work in practice and in sort of like an ordinary international organization. There are also some organizations such as the International Union for the Conservation of Nature, the IUCN, which has both governments and international organizations that are party to the IUCN, but it's not normally regarded as being an international organization as such because it's established under Swiss law. So the kinds of access that would be granted normally in an international organization is the right to speak and the right to deliver papers. And in the case of the UN, for example, there's a lot of organizations which have status as observers, and a lot of them, either give statements if it's a conference, or they have side events and they're basically advocates for civil society interests in the international organization.
Thank you. So without effective participation in the decision making in the sense of voting or being part of the consensus. So, but it is, more and more, and we saw that you referred often in your presentation to the BBNJ. I mean, the role of civil society organizations, NGOs, in the context of the negotiations of the BBNJ. I mean, negotiations like the Rome Statute of the International Criminal Courts. I mean, there was also a high level of participation, and we have that also in other areas like human rights in the Human Rights Council. So it is very common, it is very useful, but not technically part of the decision-making process in the sense of voting. So perhaps since there are no other questions, I'll ask my question, because I think it's one of common interest to us, Penny and Nilofer, and all of us involved in the work of the ILC and in the context of also the relations of the Sixth Committee. You said, and I totally agree, that decision making is relevant in terms of the legitimacy of the organization and in terms of the effectiveness of the organization. And consensus, I think it's quite relevant, especially when we speak about the legitimacy, because it is, better for the legitimacy of the organization to have decisions taken by consensus. But on the other hand, it can be an obstacle to effectiveness, because we can see decisions often blocked by a smaller number of states that oppose a certain decision, and so therefore they block the possibility of consensus without formally asking for a vote, but because there is a position of disagreement, a small minority can block effectively consensus. So I wanted you to comment on that, because it's an issue that we often discuss, and it might be interesting also for our participants. Of course, consensus is a great thing in principle and definitely in contribution to the legitimacy, but it can block the effectiveness of the organization. So I'll give you the floor. I think that would be the last question, unless we have something from the participants. Please, Penny.
No, I agree completely with everything you've said, Patricia, because consensus can be really good when consensus can be reached. But there's a real potential for a small group to block. So that's when you have to use other kinds of mechanisms to try to reach a consensus view. A lot of those other mechanisms are, peer pressure, the role of civil society organizations, and so they all play a role. But at the end of the day, there's also mechanisms such as, the time limits, stopping the clock, trying to push, trying to use a facilitator to reach agreement on something. There's all sorts of different types of mechanisms to try to reach consensus. My own view is that often these different types of mechanisms are not used enough. There's often sometimes just the chair of a conference or something saying, look, we can't reach agreement on this. I'm going to take you and you and you away, and we're going to talk about it in a small closed group, just in a small group session, to try to nut out the problem. So there's lots of different techniques like that, which I think can be used to reach consensus, and I don't think they're used enough. I think there's more opportunities to use those types of mechanism. Facilitation mechanisms, small groups, hammering out, using civil society, using political pressure. Political pressure is another one too, because the delegates to a conference may not, they may have instructions, but their instructions can always be changed if you go to the top of the state. So in answer to your question, yes, I agree with everything you've said, and consensus can be an obstacle, but I think more use needs to be made of mechanisms to facilitate and encourage consensus decision-making.
Thank you so much, Penny. And let me just conclude the lecture of today by saying how delightful it was to have you. But I think in particular how it was so evident that the explanations you gave can only come from somebody who's really had a very active experience, practical experience in working in different international organizations. And I think that's one of the benefits of the guest speakers that we have, that we try to bring to the Academy something that you don't read necessarily in the books, and that you get to hear from top experts. And again, thank you so much for sharing that with us in such a clear manner today. And I'm sure that Nilofer will also want to say something, but on my part and on behalf of the Academy, thank you so much, Penny, for your time and your dedication. And I know you had a bit of a flu, so again, we appreciate that even more, but it didn't show, so don't worry. Please, Nilofer.
Thank you, dear Patricia. I joined everything you said, and especially that you lectured not feeling well, but your lecture and obviously the responses you gave were very clear. We are very fortunate to have an expert as yourself with us today, and I join Patricia in thanking you very much, and thanking also our participants. Over to you, Patricia.
Penny.
Can I just say thank you so much
yes.
for inviting me. It was a real pleasure, and I hope if I could contribute in a small way to the eAcademy of the CIL, then I'm very happy to do so. So thank you again for inviting me.
You did, Penny, and please join me in a round of a virtual applause. Our participants, as you saw from the questions, were quite interested, and so this issue of decision making in international organizations it was really important to explore with somebody with your great experience. So thank you so much, and thank you also to all the participants for your interest. And we will see you next week. We'll have our week on environmental law. So see you all next week. Until then, take care. Thank you very much.